In the SEC versus Ripple lawsuit, the latest legal bombshell is that the SEC is trying to assert jurisdiction over areas where it has no authority under current legislation. Welcome to Coin Lady channel. I'm going to share with you views from 3 attorneys within the XRP community and including an attorney Jeremy Hogan, who brings this up, and notice exactly what's at risk here. And I just had to tell you, I have a very hard time thinking that I have a very hard time believing that because, you know, the question of XRP legal clarity has already been answered. So, it looks like this litigation will continue until next year. Does that have any bearing on the value of XRP? I seriously doubt it. There is no doubt in anyone's mind that XRP is completely legal. You can't deny it. To be honest, it surprises me that some people in our community have such views. Yes, Coinbase, what the heck, they enlisted again? XRP, is there even a single delisted exchange that hasn't relisted XRP that I can think of? Do we have any left at all? Please tell me which one it is if there is, because I have no idea if there is. It intrigues me. As far as I know, they all relist. It doesn't. Do you think they do that if there weren't sufficient legal certainty? In addition, you have witnessed the XRP price increase. In actuality, the growth rate over the past 30 days is over 36%, at least as of the time this was written down. Over the past 30 days, Bitcoin and ETH have both moved in roughly the same manner. But if you think this will prohibit XRP from functioning, I'm just not buying it. So, I won't be discussing that in terms of price movement for the remainder of the clip. I see folks who are like, I get it, I respect where you come from with the concern, but that's why I want to share my personal opinion, which is that it doesn't make sense to worry about that, so I felt compelled to at least give a blurb here at the onset. Now that XRP is free and its legal status is established, we can move forward. But it doesn't imply there aren't any other factors to think about. The battle is not over by any stretch of the imagination. I should probably mention that I have zero experience in the financial sector. Before we go any further, you shouldn't purchase or sell anything based on what I say, and I'm not a financial advisor. I'm just a fan who occasionally posts videos to YouTube discussing random crypto-related things for kicks. Special thanks and recognition go to XRP community member and attorney James K. File. This is where he dropped the bombshell. A suggested timeline for remedies, discovery, and briefing has been filed by Arrow to the judge and the other parties. And you've got today's coverage of their headline waves, SEC roadmap, and fresh court battle right here. Ripple and the SEC have presented a tentative schedule for remedies discovery and briefing to the Honorable Annalisa Torres of the Southern District of New York. In their proposal, they lay out a systematic plan for the discovery phase, during which the SEC's charges and the Ripple's defense will be investigated and presented to the court. Finally, the SEC is to be given 90 days from the entry of the schedule in order to undertake discovery relating to remedies, and the parties have agreed that this includes activities that occurred before the SEC's initial complaint against Ripple. Ripple only allows discovery into matters that occurred before the lawsuit was filed. The letter also states that Ripple can still object to any discovery requests made by the SEC after the lawsuit has been filed and ask the court to extend any applicable deadlines. In addition, the schedule entry date plus 45 days have been allotted for Ripple to submit the updated report by Anthony Imbraco, who testified earlier this year. In turn, the SEC will be able to take Bracco's deposition in the next 90 days after the scheduling order. Both sides are prepared to file rebuttal reports and request additional discovery from the court if necessary. In accordance with the Federal Rules of Civil Procedure, no discovery requests to third parties shall be made without prior court consent. Okay, so I believe that's a fairly decent distillation of what this document covered. Instead of reading the real document, which is much more dry, I thought I'd just skim that. But here's what Bill Morgan, an attorney, has to say in response. This plan will get us through until at least May 2024, when the second Bitcoin halving and the commencement of the anticipated bull market are both likely to occur. In the event that this lawsuit is not resolved before the Wave of Innovation XRP Gold Coast conference in March of 2019, we will still be able to discuss it as an open and continuing matter. We'll get there eventually, and what you're talking about is certainly plausible in terms of the bull market's future expectations. But that's also why I want to stress at the onset that I personally don't think it's going to matter for XRP price action. What Attorney Morgan thinks of that is unknown to me. However, that got me wondering, and I'd love to hear your thoughts on the matter in the comments below. However, I don't feel the slightest bit worried. Even more so when considering XRP's recent trends. Correlated motion, that's for sure. And it's the environment. It's very evident that human interference has rendered it unchecked. Look at how XRP jumped to the 4th spot in market cap the other day, passing finance altogether. This surge was temporary, but there will be more in the future. And so I think that that's a really obvious sign, things looking pretty bright for XRP. Please excuse me while I go refill my water bottle. Alright. Now, we have the following from Jeremy Hogan, an attorney. So he told me, thinking I'd find it intriguing. Since the very independence of other nations is at risk. However, the Supreme Court of the United States has ruled that Ripple sales must have taken place in the United States or on a United States stock market. So, that's a valid concern in this context. You may remember the SEC from the lengthy litigation in the SEC versus Ripple case that preceded the Torres decision on the requests for summary judgment. The SEC had plainly gone too far on many occasions. One of these was to try to assert authority over a deal that happened outside of the country entirely. However, courts outside the United States do not have the authority to hear such cases. Attorney Kogan has asked a really insightful question. The question is how they plan to avoid this. The UK, France, and Australia filed amicus papers in support of Morrison, and he wondered if they would do so again if the SEC tried to expand its jurisdiction overseas. That's a rather bad idea. And then in another post he said, by the way, if you are rooting for Ripple, threw a big kiss at CZ, that's checking things out, of course, the founder of Finance, and Finance for their win last year. The Anderson versus Binance decision had far-reaching consequences because it limited the applicability of U.S. securities laws outside of the U.S. Moreover, I did not immediately think of this instance. So, I ran a fast Google search and found numerous websites provide information on this topic. However, a news headline from April 7th of last year may be seen here. Additionally, they mention that a federal judge recently dismissed a case against cryptocurrency exchange Binance on the grounds that U.S. securities rules do not apply to a non-domestic exchange. Furthermore, the claim was filed too late to be valid under U.S. securities law. It seems like something I've been saying for years. Justice is normally served in the United States. Not completely. As with any system, there are inconsistencies and unfairness from time to time. They, however, have that covered right here. Since this is also relevant to the SEC versus replication debate, one may assume that they would also correctly predict this. Moreover, one may assume, and then there's also this now. This is actually from yesterday, but I had to mention this because there's this post on X from Gary Gensler stating his idiotic Gary Gensler nonsense. My God. It's just so funny it hurts. For the benefit of people who don't use social media. If you frequent the comments section, Max, you've probably seen a few of his posts. Laugh out loud funny. It's so ridiculous that it's funny. His inbox is constantly flooded with messages from crypto industry insiders who are angered by his damaging actions. It's so ridiculous that it's funny. In that respect, he is spot on. Of course, he's probably not managing the account, and SEC in turn is more likely to be in charge. Still, it's the typical feeling in this situation. So, a poster was placed behind the curtain. For the sake of this movie, I won't be reading it, but feel free to pause and do so. Attorney Hogan reblogged it and added, bureaucrats who regulate business should have actually started and built a business themselves. For instance, unless you've had a baby projectile diarrhea into your mouth, I don't want to be parenting regulated by someone who has never had a child. That's great news for the home visits you offer. How crazy am I? That's not insane talk at all. You, Mr. Hogan, are a rare breed of reasonable lawyers. That's why I couldn't believe my eyes when I read that headline. Take a look. Originating with the Cointelegraph, an American congressman has proposed paying SEC head Gary Gensler only $1 per year. Guys, this really pisses me off. In what way would giving Gary Gensler an extra $1 a total loss? This is quite offensive. However, in all seriousness, I am relieved. I'm glad about the notion paying this guy anything to do it like he's getting paid money to harm the investors that, his agency is promised to protect. What a revolting thing to say. In addition, Fred Rispoli, an attorney, has said this. This is nothing except reading tea leaves. But he sent me this letter, so he must be referring to the information in the attorney's file. Mo Hatha Jim, the focus of this action, is mentioned here as well, and the timeframe suggests that we are engaging in nothing more than speculation. But I do not get the same sarcastic tone in this letter as in the others. Both sides were able to reach some compromises. I continue to believe this case is closer to settlement. That's what the SEC anticipates. Yes, that would be fantastic. And I wouldn't despise that one bit. If you always project each other, even if you think your case is poor, inferior to you project the strength, then who knows, maybe we'd want to see the SEC. I appreciate the thought process behind this stance. You don't want to give in to pressure or give the impression that you're weak, otherwise the opposing side would be more aggressive than they otherwise would have been. But from the attorney's standpoint on how to respond, he thinks they look a little bit weaker, like they appear that way closer to resolution here, even if it is inadvertent. What happens next is anyone's guess, but that's the newest information I have for my friends. You shouldn't buy or sell anything based on what I say, because I'm not a financial advisor. Please like and subscribe my channel. See you later, bye.